Dennis, join the other Zoom meeting. I should be. This judgment at Industrial Court, I want to attend by this one. Okay.
Mm. You can come.
Belum. Bye. Atau ya kalau. Alo, tak betul ni. Ada jalan.
Good morning, everyone. Registrar.
Good morning.
Yes, my lord. Good morning, sir.
Morning. Good morning, Council. Set.
Yes, sir.
Set. So we can start now.
Okay, sir. Court of Nigeria in the Lagos Judicial Division, holding at today, 30th July 2021. Suit number NICS /2016 between Ademola Tani and Nigerian Social Insurance Trust and two others. My lord, parties are absent.
Okay. Okay.
May it please this honorable court.
Moshud Sani.
Yes, madam.
Hold on, Council. Let me use it.
As a copy.
Yes. You can go.
May it please this honorable court. I humbly announce my appearance for the claimant, sir.
Your name, please.
Oluseun Shogbeson.
Yes.
I appear for the claimant, sir.
Okay.
I apologize for the absence of the claimant.
Apology. Appearing for the defendant. Yes.
Chinedu G. Udora.
I cannot see you.
My lord, I'm having challenge with my video and the network.
I'm sorry, Mr. Chinedu, I cannot record you by merely hearing your voice. You either video so that we can see you, or I will record that you have not participated in the judgment. I cannot record by merely hearing your voice. I would not know who is speaking.
As the court pleases.
So I will record that there will be no appearance. There is no appearance for the defendant.
As court pleases. Just I have a challenge. I'm in the village.
May it please the court? Respectfully, my lord.
Yes.
Chukwudi Adiuku. I
Yes.
announce my appearance for the second defendant, my lord.
Okay. Chukwudi
Adiuku, my lord.
Adi for the second defendant. Yes. Yes.
We prefer respect, my lord. Bilkis Umar.
Your network is not that good. I cannot hear you well.
With profound respect, my lord, Bilkis Umar for the third defendant. Bilkis Umar. Bilkis Umar, my lord, for the third defendant.
Okay. Yes, the judgment is ready. I'll read it now. But before I start, I want to tell counsel that I will read the summary of the facts of the case, skip the submissions of counsel, and read the decision portion in order to save time.
As the court pleases.
Okay. It goes this way. The claimant instituted this suit by general form of accompanying originating processes on the 13th of December 2019, seeking for the following 2016 of December 2016 seeking for the following reliefs. A, an order that the first defendant should determine the attributable income of the claimant the period of his employment from 1968 to 2006 and remain dependent immediately. B, the post-dependent should immediately remit the contributions with it covering the period of January 2000 and December 2006, together with income to the second dependent. C, in the sum of 1 million naira for the financial hardship was made to encounter as a result of the action. D, cost of this response to the originating process, then file its statement of defense on the 2017, while the second depends on the 30th of March 2017, and the third depends on the 6th of March 2017. In proof of this case, the claimant gave evidence himself, adopting his witness statement on oath dated the 13th of December 20, as his evidence in chief, subsequently cross-examined by the defendants. During trial, the claimant also 28 documents in evidence and marked accordingly. The third defendant's file on oath through one Mr. Kelvin Chinedu, its employee, who was cross-examined, all the parties hearing and discharged. They also testified through one Abiyoyi, who was also and discharged. So also, and he was also testified. He testified. It says the first defendant testified through its employee, cross-examined and discharged. The case before the court. It is that he worked Akin George and Co. and paid Co. between the period of 1960 to 1973 and 1973 respectively. Retired. That after his retirement, he approached the second 2009 for the payment of his retirement benefits, and he was 229,937 1 kobo only. Unsatisfied with the amount paid to him, the claimant complained to the second dependent that the second dependent only paid him the amount he contributed, not qualified to receive more than that under the pension 2004, as he was not 60 years, he has not attained the age of 60, end of the transitional period specified by the Act. The claimant's case that Section 42 of the Pensions and Poor, now Section 53 of the Pensions Reform Act 2015, first dependent to compute his attribute, but the first dependent failed to do so and also failed to remit for the period of January 2005 to December 2006, amounting to the 10,000 naira only. Waited for the third defendant to take a decision on his complaint concerning the claimant further complained to the Public Complaint Commission and to the Office of the Public Defender in Lagos State. After the exchange of correspondences between the Office of the Defender and the second and third defendants, and yet the issue was claimant instituted this suit. The case of the third dependent, the requirement for eligibility for pension under the National Social Fund Scheme, the claimant had not attained the age of 60 30th 2004 when to operate. Following the Pensions Reforms Act 2004, the claimant was, however, entitled to lump sum payment. He alluded had already been paid in accordance with the guidelines for the administration under the NSITF scheme. Act beyond 2004 mandatorily transited to the contribution and to the third subjected to the Pension Reforms Act 2014 and the guidelines of the contributory pensions and pursuant to the guideline contributory pension scheme 2004. The second dependent is that the second dependence case is total retirement contribution from 1968 to 2006 is 973 naira 1 kobo, which was paid to the claimant. The second dependent that at the time the payment of the aforementioned sum for the claimant claimant still had an outstanding contribution for January 2005 to December 2006 in the sum of 110,000 naira. The case of the first dependent is that they do not have any assistance to render to the claimant with respect to his pension contribution, having been stripped of such rights and powers over funds and assets of pension by Section 53(5)(42) of the Pensions Reforms Act 2014. Hence, the claimant, to the first defendant, the claimant do not have a cause of action and right of action to institute dispute against it. I now skip the submissions and read the decision. After careful consideration of the processes filed, the evidence and submissions of counsel in the final addresses, I shall start off with the jurisdictional issue raised by the second dependent. Dependent's contention is that the claimant had referred his grievance to the commission, the third dependent, prior to the institution of this matter. And from the exhibits before the court, the third dependent to the claimant's complaint that what the Act provides is when the claimant is dissatisfied with the third dependent's decision, he is not to institute the complaint before this court, but to refer same to arbitration or to the Investment and the Securities Tribunal established under the Investment and Securities Act. To the second dependent, therefore, this court the jurisdiction to entertain this matter as the matter was never referred to arbitration or to the Investment and Securities Tribunal before its institution. The claimant's reaction in this regard is that it is a misconception and misinterpretation of law to state that disputes arising from pension must be referred to arbitration, that there is no provision in the Act that mandates the claimant to refer his dispute to arbitration. That the Act makes referral to arbitration as a matter of choice and not mandatory, with the use of the word may, just as it gives the discretion to the claimant to complain in Section 92 sub 1 and 93 sub 3, and that the word may, as used in the provision of the law, is not mandatory, as the second dependent portrays it to mean, but rather an enabling or persuasive word. The law is tried that courts must decide the issues of jurisdictions. The law is tried that court must decide issues of jurisdiction once raised before proceeding to consider any other matter. I refer to the case of OBUB versus CBN and NDUUL against Wayu and others. Citations of light. From the claimant's statement of facts, it is clear that the claimant's cause of action arose sometimes in 2009. It is the law applicable to a cause of action is the law imposed as at the time the cause of action arose and not the law existing at the time the jurisdiction of the court is invoked. I refer to the case of Zubair versus Kolawuli and Mustafa against Governor of Lagos State. Citations of light. Now, the extant law regarding pension, as at the time the claimant's cause of action arose was the Pensions Reforms Act 2004. Section 29(1) of the Act provides inter alia that any employee or beneficiary of a retirement savings account who is dissatisfied with the decision of the pension fund administrator or custodian may request in writing that such decision be reviewed by the Commission. By Section 93(1), where either party is dissatisfied with the decision of the Commission or any matter referred to it under Section 292 of the Act, under Section 92 of the Act, such party may refer the matter to arbitration in accordance with the Arbitration and Conciliation Act or to the Investment and Securities Tribunal. Section 92(3) of the Act empowers any person or body corporate that is aggrieved or dissatisfied with any action or decision of the Commission under the Act to refer the matter to arbitration under the Arbitration and the Conciliation Act or to the Investment and Securities Tribunal. And by Section 94 of the Act, any award made pursuant to Section 93 of the Act shall be binding on the parties and shall be enforceable at the Federal High Court. It is clear, therefore, from the above that under the Pensions Reforms Act 2004, an aggrieved party may report to the third defendant, and if dissatisfied with the decision made, the matter may be referred to arbitration or the Investment Tribunal, Securities Tribunal. Award shall be binding and same is enforceable only at the Federal High Court then. It follows, therefore, from the above that where the IST, a party aggrieved by the decision of the IST may appeal against the decision to the Court of Appeal. Then, the claimant in the instant case has lodged his complaint with the third defendant as can be seen from paragraphs 12, 31, and 41 of the Statement of Facts Exhibit and Exhibit C27. For all intent and purposes, therefore, the claimant complied with the provisions of the Pensions Reforms Act 2004 in reporting the matter to the third is not in dispute. The fact that the third defendant has not made its decision cannot, in my humble view, prevent the claimant's case. As rightly pointed out by the learned counsel to the claimant, it is not mandatory that the claimant must report arbitration or IST before coming to this court. The use of the word "me" in the it is not necessary that an aggrieved person must go through arbitration or investment tribunal before going to. In other words, need not wait for the third defendant before approaching. This remains the position as under Section 107 of the Reforms Act 2000. It is instructive to did not have jurisdiction in the claimant's case when the cause of action arose, contemplated in terms of jurisdiction of the Pensions Reform Act 2004. However, mean that this court cannot assume the Pensions Reforms Act 2014. I mean the claimant's case for of the pension 2004. Applicable action arose. Find support in the decision court in the case of CBN survival JS was held at to 25 paragraph. Thus, and I quote, law imposed at the time the cause of action arose is the law determining the case. The law does not necessarily determine of the court at the time the jurisdiction is invoked. C. The law enforced at the time arose governs determination of the suit. Enforced at the time of trial based on determine the court vested with jurisdiction to try the case. Example, Section 107 of came into force on 17th November 9. A litigant who had a cause of action in 1990 have his case governed by the law at the time. At the time, that is 19. Trial commences before 1993. To try the case would be the State High Court. 17th of November, the case would be tried in the Federal High Court. Decree 107 of 1999, the State High Court as from November 1996. Transferred jurisdiction in Section 2.5 of the Constitution of the Federal High Court. 17th of November 19, the State High Court jurisdiction. So Lord referred to the against AG Bender and other against AG Bender, other NYSC. Citations applied. Continued, jurisdiction of an action is determined by examining the jurisdiction at the time the institute the suit trial commences. End of quote. I now turn to the merit of the claimant's case. Agent that is attributable income covering the period of his employment from 1968 to December 2006 by the first dependent, and that his pension contribution for the period from 2005 to December 2006 was not remitted by the first dependent, and thus prayed for this court to order the second dependent to determine the attributable income, to order the third dependent to direct the second dependent to attribute his attributable income and to remit same along with his contributions from January to December 2006. Now, in the case of Muhammad Dungu versus ENL Consortium applied, this code, labor relations, the body someone who claims money to prove not only entitlement to the sums, / came of the sums, and the entitlement is obtained by reference to an document that grants it. The claimant is by law required to lead evidence to establish his entitlement income being claimed. How much is it? How he arrives at the calculation, and how much was paid to him, if any, and the remaining balance. As for the claim of the claimant's contribution from January to 2005 to December 2006, the claimant is expected to plead and prove the amount he is entitled. The claimant averred at paragraph 6 of the statement of facts that he had made monthly contribution to the Provident Fund between 1968 to June 2000. Between 1968 to June 1990. His contribution were transferred to its successor, that is the first dependent. These abatement dependent at paragraph 4 of its statement of defense. It therefore become a bounding duty on the claimant to prove that deductions were actually made from his salary as pension from 1968 to June 1994, inherited by the post-dependent from the defunct National Provident Fund. The claimant admitted under cross-examination that he has no evidence of the contribution during the period before this court, that at 2004 he has not attained the age of 60 years, and that the second, the sum of 229,939 kobo, and that he would not know if the second session of any money due to him. The law that pleadings are not evidence and not led to support averments in the plea, averment is deemed abundant. I refer to the case of Ipeta PDC, Nigeria Limited, citation supplied. Performance Distributions Limited, Samsung Electronics, and another citation. The case of Uzodimma and Hedioha, Omoborio against addition supplied. In the instance, averments in the statement having not been supported by evidence are therefore deemed, I find, and I saw her. In the final written address, Learned Counsel sought to rely on the defendant to prove case as on the defendant's case, the claimant's case, as if the burden rests on the defendants. This is not the law that the discharge of the burden on the, it is after the discharge of the claimant that the burden shifts to the claimant case. To my is built and supported by, and the law is that court litigation do not act on superior. The courts act empirical facts, parties and law. I Aolola, Ekiti State and Governor of Akwa Ibom and others, but in the final analysis and for it, I find that the tax merit, it fails and is dismissed. Judgment is entered. I make no order for cost.
As God pleases.
Sir, are you with us? Yourself. You have mute yourself, please. I'm done with the first judge.
Okay.
All the second case.
Suit number
All the
NICS.
counsel have muted themselves. Yes.
Suit number NICS/SA/252/2017 between Mr. Abubakar Ibrahim and 3 others, and Dangote Cement PLC. Yes, sir.
Yes.
Hello. The first claim present, sir. Defendant is absent.
The other claimant. Is the first claimant representing the?
Yes.
Yes.
May it please your lordship. Hello, my lord. E.A. Okori appears for the defendant.
E.A.
Okori.
Okori.
Yes, my lord. My lord, I have my learned friend, O.E.K.
O.
Ige.
Ige. Okay.
Yes, my lord. Yeah, my lord, our representation is for the defendant.
For the defendant. Yes.
Yes, ma'am.
Any appearance for the claimants?
Yes, my lord. Abubakar Ibrahim.
Are you a lawyer?
No,
Are you a lawyer? You are one of the claimants. I have already representing the other claimants. I am calling for your counsel to enter to announce appearance. It appears he is not present.
It's not my lord.
The judgment is, and I'm going to read it now. The introduction, reliefs, summary. I will skip counsel submissions and read the decision portion. It goes this way. The claimants on behalf of themselves and filed this action in representative of May 2017 by general form of complete parts, list of witnesses, and list of documents, praying for the following reliefs. 1. A declaration that the manner and mode of termination of the claimant without 7 days notice as contained in the scheme of agreement practice, unlawful and contravention agreement and the relevant provisions of the Labor Act. 2. Declaration that it is a gross violation of the rights of the claimants as contained in Chapter 4 of the Constitution of the Federal Republic of Nigeria as amended, to have subjected them to inhuman and degrading treatment, using armed policemen to make them sign letter of termination and treating them like criminals. 3. A declaration negligence / refusal of the defendant to truck ownership as represented and made believe in the newspaper is fraudulent representation. Defendant must provide a remedy. So, an order the payment of the following as contained in the process and reply of defense. 513 claimants for 8 to 9 months, May 12, 2013, May 12, 13 in the year 2016. Outstanding salary of 6 per month based on of an average of 6 trucks for 8 months, the total of which 880,000. 2. Outstanding operating additional 6 trucks for an average of 8 at the rate of 90,000 per truck. Going 12.2 of the scheme of agreement C2/D1 stands at 4,320,000. Allowance, that is 30% of their, which is 144,000. 4. On 2017 salary to the tune of to the claimant each. 5. On part of the, that is 12.5% respect of 8-month salary, which is to each of the claimant. 6. Salary in lieu of notice, which to each of the claimant. Equivalent monetary 1 truck, that is 30 to each of the claimant. 8. breach of human rights, dignity, and inhuman treatment, coercing the claimant to letter under the supervision and mobile phone. This is discretion. Then the PIPs release pray for an order of this court for the total sum of the 513 claimants, both in batch A and B, issued in favor of the claimants' counsel, Mr. Toluwani Adebi, to bend the fight back rule attitude of the department of paying into account of employee group, while the matter is in order to scatter their aim. And for such further order, or this honorable court may deem fit to of this case. The defendants in response filed a statement of claim, which it later amended this court. And in response to the claimants filed additional list of to counterclaim. Pleadings were closed and the case claimants called 2 witnesses while the defendant called 1 witness, which were attended by the party admitted and marked the fact of the case. The defendant presentations in the case, it is the case of the claimant that the presentation in the national newspapers, in the Nation newspaper of June 24, and another national newspaper of highly rewarding offer of graduate truck officers that will eventually entitle them to become owners of a truck, a monthly salary of 60,000 naira, and a performance bonus of 90,000 naira upon meeting certain conditions. About 800 Nigerian graduates were allegedly induced to leave their former work to join the workforce. Scheme of agreement of 1 truck at a time, 60,000 naira monthly salary, 90,000 monthly performance bonus, 7 days notice before termination of contract and other terms were signed on oath. Letter of appointment with medical allowance, leave bonus, and other benefits entitlements followed. Each truck officer was to appoint a driver to be attached to the truck and under their supervision. It is the claimant's case that within 2 weeks of the engagement and in breach of the scheme of agreement, that is Exhibit C2/D1, the defendant allocated additional 6 to 8 trucks to each of the claimants, thus increasing their workload, using them as beasts of burden for about 8 to 9 months, contrary to the 6 months stipulated in the agreement and without a commensurate salary and performance bonus on the additional 6 to 8 trucks. It is the case of the claimant that the unrewarded and inhumanly increased workload led to the death of one Oyelami Adekule Ismail, who slumped and died under the burdensome, slippery, and unprotected service of the defendant. That some women under pregnancy suffered miscarriage. That the inhuman treatment of one Ms. Ejumoke cannot be forgotten in a hurry. It is the claimant's case that in February 2017, they were summoned through WhatsApp to the office and made on arrival fully armed, bloodthirsty soldiers and mobile police supervised their signing of termination letters without the required 7 days notice. That the claimant's ID cards were yanked up from their necks in the most embarrassing manners, and those without theirs were loaded in Hilux jeeps and carted away like captured animals / criminals to their various homes to get their ID cards. The alleged reason for this wrongful termination was the claimant's performance. The alleged reason for this wrongful termination was that the claimant's performance was not satisfactory and that they were of bad conduct, and that till date, no warning / query letter was query letter as the normal practice was issued or pleaded or even tendered in evidence. That on the contrary, there is a letter dated 25th of January 2017 evidencing satisfactory performance issued by the defendant beside a key performance indicator, KPI, of the defendant's strategic finance report that not only buttresses the claimant's commendable performance, but also contradicts the mischievous allegations of non-performance. It is the claimant's case that the monthly salary of 60,000 naira per month per additional trucks of 90,000 naira per month was not also paid. That pensions are issued to the claimants, pension deduction, that medical and other benefits were never fixed. The contract, as advertised in newspaper, was of an offer which with conditions and condition and reward of a truck. That the claimant accepted the offer, overmade the conditions with unimpeachable evidence, yet denied the reward of a truck or monetary equivalents and other benefits they are entitled to by virtue of the evidence of the contract. It is for these reasons that the 513 claimants, that the 13 claimants filed this suit in representative capacity. The case of the defendant. It is the defendant's case that sometimes in 2015, the defendant is advertised for the post of truck officers from suitably qualified individuals, as shown and contained in page 66 of Tuesday, the 22nd day of April, 2015, publication of the Guardian newspaper and the Nation newspaper publication of Wednesday, the 24th day of June, 2015. Following the said advertisement, several persons, including the claimants hereof, applied for the advertised job in the defendant's company. Truck officer scheme of agreement dated the 31st of March 20. Parties hereof entered into contract of employment defining that would regulate and guide the relationship of the parties hereof. That the claimants willingly and freely choose to enter into an employment contract and scheme of agreement with the defendant because they consider the facts, terms, and conditions of the said contract agreement favorable and beneficial to them and their interest. The terms and conditions of the agreement that regulated the parties' relationship were clearly, expressly, and unambiguously spelled out in the said truck officer scheme of agreement, admitted and marked and in evidence during trial and marked as exhibits C2/D1. Further to the aforesaid truck officer, parties hereof by letters of employment variously 2nd 2016, that is exhibit C9, further terms that will regulate their contractual relationship thereof. Upon the expiration of the duration of the employment contract, the defendant, by a letter dated 4th of February 2017, formally terminated the contractual relationship existing between the parties hereof. By the express wording of the truck officer's scheme of agreement, that is exhibit C2/D1, the contract of employment that existed between the parties hereof was for a temporary period, duration of 6 months, subject to extension by mutual agreement. That the parties hereof did not agree to extend the contract of employment and in fact did not extend same. as required by the scheme of agreement, that is Exhibit C2/D1. None of the claimants continued in the employment of the defendant for a period that none of the claimants continued in the employment of the defendant for a in line with the terms and conditions of parties' contract of employment, the 29th day of March 2017, through the bank account, paid the sum of to each of the claimants, being their respective and benefits computed and in accordance with the terms and conditions of the employment contract. Being dissatisfied with the entitlements paid to them by the defendant, the claimant commenced themselves and about 500 other truck officers for the Honorable Court for the reliefs already mentioned. This is the lengthy part of the case presented by both parties. I now proceed to read the decision of the court. Having summarized the submissions of the parties and their respective final addresses, I shall now resolve the defendants' objections to Exhibit C14 and C15. The defendants objected to these exhibits on the ground that the said exhibits are paint copies. That the claimants failed to tell this honorable court the whereabouts of the originals, that the said documents are inadmissible, and that the claimants failed to lay proper foundation for the admissibility of the said documents. That the documents are not pleaded by the claimants, and that the documents are not relevant for the purpose for which the claimants tendered them. The claimant's reaction in this regard is that the exhibits that the said exhibits were tendered and admitted in this court, and no objection was raised at the trial. The claimant therefore submitted that it is tried that documents which have been validly admitted and marked as exhibit cannot be expunged, that it is settled in plethora of cases that once a piece of documentary evidence is legally admissible and its admission was not objected to, the opposing party cannot later complain of its admissibility, not even on appeal. Now, I agree with the argument of the learned counsel to the defendant that Exhibit C14 and 15 are copies and no foundation was raised before they were tendered in the proceedings of December 5, 2019. And this offends the provisions of the Evidence Act 2011. But I find it difficult to agree with the learned counsel over the other grounds of the objection. I am at one with the submissions of the learned counsel of the claimant in his reaction to the effect that in law, documents in support of a pleaded facts need not be specifically pleaded to make them admissible once sufficient materials in respect of a document are averred to. It shall be sufficient upon the pleader to rely on same. Thus, documents in support of pleaded facts can be tendered and admitted even though the document itself has not been pleaded. I refer you to the case of Uchichuku and another versus Binkan and First Bank Nigeria PLC versus Onoyangi. I also agree with the learned counsel to the claimant that where he referred this court to the paragraphs of the claimant's statement of facts to paragraphs 11, 5, 7 of the claimant's statement of facts and paragraphs 10 and paragraph 10 of the reply to the dependent amendment statement of defense. dated the 1st February 2019, wherein the claimant referred to truck allocation paper revealing 4, 5, 6, 7, and 8 trucks instead of one truck, as contained in the scheme of agreement, that is Exhibit C2 and D1. The claimant's failure to lay foundation cannot, in my humble view, render the documents inadmissible, given that the defendant is not attacking the authenticity of the exhibits. This court is enjoined by Section 12 of the Act establishing it to depart from the provisions of the Evidence Act where the interest of justice so demands, and this is one of such instances. This being the case, I find that Exhibit C14 and C15 have passed the 3 main criteria that governs the admissibility of document in evidence, because they are pleaded, they are relevant, and they are admissible in law. And I so hold. I refer to some authorities here. Turning to the merit of the claimant's case, the claimants are challenging the manner in which their appointments were terminated, the alleged gross violation of their fundamental right, and breach of contract. It is for these reasons that the claimants pray for 3 declaratory reliefs and 2 consequential orders. Now, as rightly argued by the learned counsel to the defendant, that it is tried law that he who asserts must prove, and by virtue of Section 1331 of the Evidence Act 2011, the burden of proof generally rests with the claimants, where rest on the claimants. And the law is tried that he who makes a positive assertion has the burden of proving same. I refer to the cases of Olasa against Izimo, Husseini against Obukiri, and Odia against Piedmont Nigeria Limited, and other cases. I supplied citations. The claimants' reliefs A, B, and C are declaratory, while relief D is for consequential order in the form of special damages. It is the law that a party seeking for declaratory relief must prove his case to the satisfaction of the court and to win or lose on the strength of his case and not on the weakness of the defense, even in the face of admission that he is entitled to the relief sought. In other words, the burden is on the claimant to establish his case by satisfactory evidence. I refer to the case of Dumes Nigeria Mokoba, Chukuma against Shell Petroleum, and against INEC. It is also the law that special damages are pleaded and strictly proved to the satisfaction of the court. I refer to the case of Oguntadi and another versus Ogun, Ibrahim and others versus Obaji, GFK Investments Nigeria Limited against Nigerian Telecommunication PLC, and Oladihin against Continental Textiles Mills Limited. Now, contracts of employment, like all other contracts, their creation and termination are both subject to the general principles governing the law of contract. Hence, where a contract is in writing, as in the instant case, the parties are bound by the express terms and conditions so stipulated. I refer to the case of Olanian against Unilag, citation supplied. The claimants averred at paragraph 6 and 7 of the statement of facts that the defendant advertised a truck entrepreneur scheme seeking to empower graduates financially, culminating into eventual ownership of a truck, each on completion of a fixed mileage, that they left their gainful employment and applied, and that they were trained by the defendant at Obajana in Kogi State. The claimant tendered Exhibit C1 in proof of the said advertisement. Now, let me state here that the advertisement made by the defendant does not in law constitute an offer. It is not so, it is no more than an invitation to trade, which is the first step of negotiations between the parties to a contract, which may or may not lead to a definite offer being made by one of the parties to the negotiation. So an invitation to treat is not an offer that can be accepted to lead to an agreement or contract. I refer to the case of BFI Group Corporation against BPE and BPS Construction in Engineering Nigeria Limited against FCDE, Citation Supply. Now, it is not in dispute that the contract giving rise to the present suit is a contract for 6 months probationary period. The scheme of agreement between the parties herein, which the claimants individually signed by the, the scheme of agreement between the parties, that is Exhibit C2/D1, individually signed by the claimants on March 30th, 2016, and endorsed by the Commissioner for Oath on March 31st, 2016, provides that the duration of the contract is 6 months, but did not state the date of commencement, and that at the end of the 6 months, parties shall agree whether to extend the contract subject to the performance of the truck officer and the performance of the said agreement. See generally clause 2 of Exhibit C2/D1. Regarding mode of termination, clause 3 states that notwithstanding anything to the contrary, the agreement shall be determined by either of the parties, often given 7 clear days written notice to the other party. Now, clause 18 provides that the contract constitutes the entire agreement between the parties in relation to its subject matter and supersedes all prior agreements and understanding, whether oral or written, with respect to such subject matter. There are no amendment of the said agreement or waiver of any obligation therein shall be effective unless reduced to writing and signed by persons who are duly authorized by the respective parties to enter into the contract or to make amendments to same. That the contract, that is Exhibit C2/D1, may be executed in one or more counterparts, and that any counterpart or set of counterparts executed by both parties shall constitute the full and original contract for all purposes. Also not in dispute is the fact that the claimants were individually issued with offer of employment, that is Exhibit C9, which states that the appointment would be for a probationary period of 6 months, during which the appointment will be terminated without notice if found to be unsatisfactory. That at the end of the probationary period, and provided the performance is satisfactory, the appointment will be confirmed in writing as permanent. That from the date of assumption of duty, other terms and conditions of service of the company of the defendant will apply to any of the claimants so confirmed. It follows, therefore, that the employment relationship between the parties is governed by Exhibit C2/D1 and C9. It is instructive to note that both exhibits did not provide for the payment in lieu of notice in the event of termination, but that can be implied into the said agreements I find and I supplied some authorities here. The law is tried that where a contract is contained in a series of documents or letters or correspondences, the court is under a duty to consider the whole of what has passed between the parties in order to decipher what letters are saying with regard to the relationship between the parties. I refer to the case of Akinyele and another versus Adewale, Oga against Ifiazu, citation supply. Now, the claimant's argument is that the contract was determined in breach of the terms agreed between themselves and the defendant herein. To my understanding, the combined effect of exhibits D1/D2 and C9 in this regard is that the contract between the claimants and the defendant was for a probationary period of 6 months and can be terminated without notice during the said period. It follows, therefore, that if at the expiration of the 6 months probationary period, the defendant continued to retain the services of the claimants employment are deemed confirmed in law. This being the case, I find that the claimant's fixed term of employment having not been extended or confirmed in writing by the defendant terminates by the defendant and by allowing the claimant to continue to work beyond the 6 months probationary period, the said appointment is a law deemed confirmed. I'm therefore at one with the learned counsel to the claimant in this regard that the employment contract was terminated in breach of the agreement of the parties. I find and I so hold. Although the claimants were paid 1 month's salary each about a month after confirmation, the said payment is not contemporaneous with the termination of the contract. I cite some authorities here. The claimants, having accepted the payment, cannot now turn around to claim for damages for wrongful termination, and having regard to the fact that the letter of termination has also referred to the said payment. See the case of Chukuma versus Shell Petroleum, where Bello JSC, as he then was, held thus, and I quote, I skip the quotation. The claimants have also not brought any evidence before this court to show that they were promised each a truck by the defendant upon meeting a certain target of mileage. A careful perusal of exhibits D1/C2 and C9 will show that no term is contained in any of them to the effect that claimants would each win a truck upon meeting a certain target. I am therefore in total agreement with the learned counsel to the defendant that there is no paragraph in the said exhibits where reference is made to any newspaper publication, and neither is there any paragraphs in the said exhibits where any promise of truck ownership is made or stated. It is the law that where parties are ad idem on the terms of contract, the function of the court is to give effect to the terms without more, as it is the duty of the court to give effect to the intention of the parties. I find support in the decision of the Supreme Court and in the case of BFI Group Corporation versus Bureau for Public Enterprises, where Babi JSC made a pronouncement. I skip the pronouncement. The claimants having voluntarily signed exhibits D1/C2 and C9 cannot claim entitlement to any benefit outside those mutually agreed in the said exhibits. I find and I so hold. The allegation of human rights violation made against the defendant at paragraph 18 of the statement of facts, which was denied by the defendant at paragraphs 19 and 20 of the amended statement of defense, was not proved by the claimants during trial. It is tried that pleadings without evidence are worthless. See the case of Cameroon Airline and Mike Otutuzu and Uzodima and another against Ihedioha and Omoborio against Ajasin. Citation supplied. At paragraph 22 of the amended statement of the statement of facts, the claimants prayed for certain reliefs in the nature of special damages, as rightly pointed out by the learned counsel for the defendant, but they failed to prove their entitlement to any of the items claimed. In the case of Muhammad Dungus against ENL Consortium, this court held that in labor relations, the burden is on the claimant who claims monetary sum to prove not only the entitlement to the sums, but how she or he came by the quantum of the sums, and the proof of entitlement is obtained by reference to an instrument or document that grants it. In the instant case, the claimants merely itemized what they are claiming under this relief, but failed to plead any evidence of their entitlement to this relief. The claimant only tendered Exhibit C17, the certificate of registration for pension of one of the claimants with Pension Alliance Limited, which did not show any evidence of deduction made from the bearer's salary. The claimant have also failed to tender even the respective bank statements or respective bank statements or payslip in support of the deductions and non-remittance. In sum, and for all the reasons given, I find that the claimant's case failed for lack of evidence, and it is accordingly hereby dismissed. The defendant made a counterclaim against the claimants for the following reliefs: an order that the defendants to counterclaim shall pay to the counterclaimant the sum of 10 million naira being cost incurred by the defendants in defense of this suit and the counterclaim hereof. 2, an order for payment of 21% interest on the claim sum aforesaid from the 7th day of July 2017 till judgment, and thereafter until the judgment sum is fully liquidated. The defendant, other than reproducing the above reliefs in the written deposition of its witness on oath and tendering of exhibits depot, which is the solicitor's P note, did not lead any evidence to prove the amount being claimed, to prove that the amount being claimed has actually been paid to the solicitor. This, I think, falls short of the requirement for the proof of counterclaim. It is the law that a counterclaim, being a separate action, is bound by all the rigors inherent in proving the assertion made, and it will not succeed if the defendant did not establish it. I refer to the case of Alba Bello Trading Company Limited against Hawa Bamayi and NBC PLC versus EFO, citations of light. For the foregoing reasons, I find that the defendant's counterclaim lacks merit, it fails, and is accordingly hereby dismissed. Judgment is entered accordingly. I make no order for cost.
God bless you. My Lord, we are indeed very grateful for this cerebral. We thank you, Lordship, for the sound judgment.
Thank you. Next.
Suit number NICN/LA/441/2017 between Joseph Agbaku and Telesupricon Nigeria Limited. Parties are absent, sir.
Parties absent.
Yes, parties absent.
Representation of counsel. Representation of counsel.
Yes.
Oh. Yes.
May I please the court? W.S. Madu is my name.
W.S.
Madu.
Okay.
As in M-A-D-U.
W.
S. Initials. Madu,
yes.
M-A-D-U.
Yes.
The adherence is for the defendant.
Yes.
Respectfully, sir.
Yes.
I am GM Babu. I appear for the claimant, sir.
Okay. Yes. The judgment is ready. Like the previous ones, I will read the introduction, the reliefs, the summary of the parties' case, and I will skip the submissions and read the decision portion.
As a court pleases.
Go this way. By a complaint dated and filed on the 14th day of September 2017, the claimant commences suit against the defendant claiming for the following reliefs. 1, a declaration that the claimant is entitled to payment of the sum of 1,260,000 naira only being the sum accruable to him as his pay-off entitlement. 2. A declaration that the claimant's term of employment with the dependent company are binding on the parties and superior to any other document. 3. Declaration that the claimant is entitled to the payment of general damages for his pay-off entitlements withheld by the dependent from 2012 to date. 4. Payment to the claimant by the dependent of the sum of 1,260,000 naira, only being the sum accruable to the claimant as his pay-off entitlement. 5. Interest on the sum of 1,260,000 naira only at the prevailing market rate per annum from May 2012 till the sum is completely and totally liquidated by the defendant. The defendant filed its statement of defense. Thereafter, the claimant files reply to the statement of defense. The matter went for trial, and trial concluded, after which parties filed final address and adopted same. Documents were tendered and admitted. The case before the court. The case of the claimant is that he was employed by the dependent company sometimes in 2006 and was issued an identity card to that effect. He worked in different capacities and rose to become a supervisor of the dependent company. The position he held until he left the company of the employment of the company in May 2012. And that since his employment by the dependent company, he worked diligently and discharged his duties without any blemish or complaints from his employer. Without any blame or complaints from his employer, and he carried out his duties with the highest professional standard as his office required and standard practice of the dependent company. Claimant abad that in 2006, he worked with one Mr. Tuari, the project manager on the project from Asaba to Abu in Delta State. And in 2007, he worked with Mr. Tuari as project manager in the same year. He also worked with one Mr. Ganish in Lagos, all on the dependent projects. The claimant about that in the year 2008, he again worked with Mr. Tuari on the project from Ife to Ibadan, and later worked with Mr. Banju in 2009, he worked with Mr. Robin on the project from Mokudi to Yola, and finally in 2012, he worked with Mr. Suju on the contract from Mokudi to Ogoja, on the project from Mokudi to Ogoja, and voluntarily withdrew his services from the dependent 7 years after. And after 7 years service, and upon his voluntary disengagement, he requested for his pay of benefits and entitlements, which he merited by virtue of the years of service he had with the dependent, and the agreement made with him before he was hired. However, same was refused on the ground that he voluntarily disengaged his services. Therefore, he is not entitled, and therefore he is not entitled to the pay of entitlements. It is the dependent's case that the claimant was not engaged by it, that he was engaged by one of its engineers to enable him execute the engineer's project with the dependent. To the dependent, therefore, the claimant was never its staff, but rather a laborer engaged by the dependent's engineer to execute a project at a site. Not the facts of the case as presented by both parties. And now skip to read the decision. After careful consideration of the process is filed, the evidence laid, and the submissions of counsel in the final addresses, I shall start with the ruling over defendant's preliminary objection. During trial, the defendants urged this court to dismiss this suit because it is incompetent and did not disclose a reasonable course of action against it. The grounds upon which the application is brought are: 1, that there is no any kind of contract of employment between the claimant and the defendant; that there is nothing placed before this court by the claimant to support the assertion of being a former employee of the defendant. 3, that consequent upon the above grounds, this court lacks the jurisdiction to hear this suit for want of course of action. The preliminary objection is supported by 12 paragraphs, affidavit, and a written address. In reaction, the claimant filed a counter affidavit of 6 paragraphs and a written address in support. I have painstakingly examined the grounds upon which the preliminary objection is brought, the affidavit evidence, and the submissions of learned counsel in the written addresses in support and against the application. Now, the general rule is that an employment contract can be in any form and not necessarily in writing. A contract of employment may be inferred from even the conduct of the parties, if it can be shown that such a contract was intended, although not expressed. I refer to the case of Mobile Producing Nigeria Unlimited and another against Udo from Udo. Citation supplied. In the instant case, the claimant averred at paragraph 3 of the statement of facts that he was employed by the defendant sometimes in 2006 and was issued with ID card, that is Exhibit C1. To that effect, the defendant's averment at paragraph 7, 11, 12, and 13, also 16 and 18, are to the effect that the claimant was employed. The defendant averment at paragraph 7, 11, 12, 13, 16, and 18 of the statement of defense are to the effect that the claimant was employed at various points over a period of time on temporary basis by the defendant. This, in my view, establishes the existence of employment relationship between the claimant and the defendant. I therefore find that there was employment relationship between the parties herein, and I so hold. Next issue is whether the claimant's statement of facts discloses a reasonable course of action against the defendant or not. Now, in law, a reasonable course of action is a course of action with some chances of success when only the allegations in the pleadings are considered, and in determining whether there is a reasonable course of action or not, reference must be made to the statement of claim. See the case of Mutual Benefit Assurance PLC against Access Bank, citation PLC, citation supplied. In the instant case, I have examined the claimant's statement of facts, and I find that some questions have been raised therein which this court can inquire into in order to find out the truth of the claimant's claim. This being the case, I find that the defendant's preliminary objection lacks merit and is accordingly hereby dismissed. The claimant's case, I now proceed to determine the merit of the claimant's case. The claimant's case is founded on terminal benefit, based on which the claimant claims for 3 declaratory reliefs and 2 consequential orders. It is the law that a party seeking for a declaratory relief must prove his case to the satisfaction of the court and to win or lose on the strength of his case and not on the weakness of the defense, even in the face of an admission that he is entitled to relief sought. In other words, the burden is on the claimant to establish his case by satisfactory evidence. In the case of Dumes Nigeria Limited against Unwakoba, Chukuma against Shell Petroleum PLC, and CPC against INEC, APP against INEC, citation supplied. Followed therefore from the foregoing authority that the claimant's the claimant must lead evidence to establish his entitlement to the reliefs being sought in this case. The claimant's reliefs are monetary in nature and in the class of special damages. It is the law that special damages must be specifically pleaded and strictly proved to the satisfaction of the court. I refer to the case of Oguntadi and another against Ogun, GFK Investment Nigeria Limited versus Nigerian Telecommunications PLC, and Oladehin against Continental Textiles Mills Limited, citation supply. This court, in the case of Muhammad Dungus against ENL Consortium Limited, citation supplied, held that the burden is on the claimant who claims monetary sum to prove not only the entitlement to the sum, but how she or he came by the quantum of the sum, and that proof of entitlement is obtained by reference to an instrument or document that grants it. In the instant case, the claimant was not issued with employment letter. The relationship between the claimant and the defendant was governed by oral contract. This does not, however, take away the onus on the claimant to establish by credible evidence his entitlement to the reliefs being claimed. At paragraph 10 of the statement of facts, the claimant averred that the total amount accruable to him from the dependent company as pay of benefits for 7 years is 1,260,000, which includes his basic salary in the sum of 30,000 naira, to be divided by 2 times 12, which is 180,000 naira, which if multiplied by the number of years the claimant claimed to have served the defendant, that is 7 years, will give 1,260,000 naira. The claimant did not, however, lead evidence in any form to prove that he served the defendant for 7 years. There is also no evidence to show how terminal benefits or pay-off between pay-off benefits are paid to staff that exited the defendant's company. The claimant's case therefore suffers from the dearth of evidence. The effect of the claimant's failure to lead evidence in proof of the above averments is that the averment is deemed abundant. See the case of Yusuf Yetunde and Omoborio against Ajasin, citation supplied. This being the case, and in the final analysis, for all the reasons stated, I find that the claimant's case has failed and it lacks merit and is accordingly hereby dismissed. Judgment is entered accordingly. I make no order for cost.
As call pleases.
Yes, Registrar.
Yes, my lord. That will be all for today.
Okay, okay. The court shall rise.